welcome to the Australian Society of Building Consultants, guys. Very esteemed company here now. Well done, and to Troy as well, who's not here today. But yeah, look forward to your contributions and input to the society. I think you'll add a lot. So well done. All right, we'll move straight on to the legal update. So I think we've got Mark up first, have we? And then Dave? Yeah. We're old school.
What have we got?
So
yeah, good.
David. Dale's got control, and then you give me back control, Dale. There we go.
And then just...
Oh. Little lag. Is it? Can you go back, Dale?
So it's Dale driving, is he?
We should be able to drive here. We tested it before and it worked. Forward arrow.
Right. Yeah, righto. Righto. Good-o. All right, thanks, Mark. Morning, everyone. Thanks for the opportunity again to come out with the legal update with David. As we often do, we're going to do a two-part show. I'm just going to talk about an update in the combustible cladding space and Project Remediate, and then David's going to talk about expert evidence in the era of video links. So I want to just talk about this new project, or the government initiative called Project Remediate, which was announced in the Berejiklian budget towards the end of last year. And what Project Remediate is it's a 3-year program by the government to help remove the combustible cladding on the 255 odd buildings that have been identified by the cladding task force. And their stated aim is to fast track the removal of the cladding, and they've allocated some funds to help coordinate. So they're not actually going to do the removal work or the remediation, but to coordinate the remediation process on these affected buildings. And under the project, they're going, or the auspices of the project, they're going to provide the owners of these buildings, so the owners' corporations, with some financial and technical support to manage the remediation process. So the government's position, I suppose, is best stated out in this announcement that under the program, the government's going to confirm that by 2023, so it's a 3-year program running till 2023, to help safely remove high-risk combustible cladding on these estimated 225 buildings, and they've allocated, as I said earlier, some $139 million to provide this assistance. So it's a loan scheme. So what the government is going to do is it's going to pay the interest. It's not going to provide the loans, but it's going to pay the interest on a 10-year loan that is to be provided by the owners' corporations to undertake this sort of work. And the repayments of this will commence on completion of the remediation work. So the owners' corporations are still going to have to find the money to carry out the actual remediation and to secure the loans, but the government is going to pick up the interest on those loans over a period of 10 years. Project Remediate has got an office of Project Remediate been established under the Office of the Building Commissioner, so David Chandler's involved in this as well. We've all seen and read a fair bit about what he's been doing as he's in his quest to put some credibility or some reliability back into the project. He's got more power here. He's going to be establishing and managing this program from within his office over the next 3 years. And the building owners are going to be invited, or they'll be contacted and invited to participate in the program. So as I said, there's 255 odd buildings that have been identified. Presumably they've been identified through the fire department in inspecting, and also we had that process some time ago where buildings that had combustible cladding had to register on the government portal. So between those various sources, this list of 255 has come up, and they will be contacted and invited to participate in the program. Which buildings will be eligible? So they're the residential, the Class 2 buildings, and they have to have been confirmed by the task force and a consent authority to have high-risk combustible cladding. So it's quite specialised and specific in terms of the buildings that will qualify, but it's Class 2 and those that have been identified by the task force as having combustible cladding that requires remediation. There'll be a property assurance service provided as part of project remediation that'll work with the owners and provide them with some project management services. Their aim is to ensure that the rectification is done to a high standard, and that'll come at no cost to the building owners. So the building owners will be able to avail themselves of the services of this project assurance service provided by the government as part of this project. So other partners that the government will be involving in this, obviously they're going to appoint a managing contractor to oversee each individual project. So at this stage the government received or been made aware of any other details than that, but it would seem that they're going to make an appointment to oversee specific in each of the individual projects. The government's also called for tenders for financial service providers, so those that might be interested in providing these loans to owners' corporations over the 10-year term to carry out the remediation work. So you can see there's a lot of support services there. The intention is to provide support services that should provide for meaningful and speedy rectification work of this cladding. There's also going to be a principal designer appointed who's going to be the source and repository of design expertise through the program. So this principal designer will work with the individual project designers to ensure that the design that's put forward for this remediation work is suitable for each building. So again, there's no further detail than that being provided at this point in time. I would assume that the principal designer will sit somewhere within the office under the control of David Chandler and be providing an overall design service or some design specialist advice to the individual projects and to the individual designers engaged in each of the specific projects to ensure that the remediation is suitable for each building. So that's it's just not working. So that's the update just on combustible cladding. As I say, it was announced in the budget. There's been some funds allocated, and applications will start at the beginning of March. So you would reasonably expect that building owners on that list will be contacted with a view to kicking off this project under the management and supervision of the Office of Project Remediate. Okay, any questions? Probably a lot of questions as to how it will all work and how the principal designer will work with the project designers and what level of assistance will really be there, and whether the party that's finally nominated to provide the funds or the parties provide the funds, to what extent, whilst the interest is being covered, obviously there's all the usual lending criteria that will need to be met by the various owners' corporations. It'd be interesting to see whether financiers have got an interest or an appetite for 10-year loans. That's a bit longer than one normally expects, so we'll just have to wait and see what comes of that. But that's the government's announcement and initiative with respect to combustible cladding.
What's the principal designer's liability in all of this?
A very good question. At this stage, I don't know. We haven't seen any details. It's unclear as to exactly what that service is going to look like, whether they issue guidelines or some sort of criteria that needs to be met, that the individual project designers are going to have to be met. What will be their liability? It's hard to tell, but I can imagine limited, I would have thought. Would you agree with that, David? I mean, a principal designer engaged by the government is unlikely that there's going to attract...
Well, presumably it's either going to be a government bureaucrat, as in actually employed by the government, or contracted. No doubt we'll be asking for all sorts of
indemnities.
But no responsibility.
Well, it's easy to conclude that yes, that might in fact be the reality of it all, and to what extent they're able to influence or dictate or mandate the designs on the individual buildings and influence the specific project designers. you know, time will tell. We've certainly seen, again, anything with the building commissioner, that they're pretty strong on what they do and don't want.
And will this all be subject to getting development approval or construction certificates?
I can only assume that the usual processes would apply. I can't see. There's certainly been nothing alluded to that would suggest that there's going to be any waiving or deviation from the usual application processes that you would ordinarily expect. So the answer to that will be, you know, as usual, I would suspect.
Mark, my question's a financial one.
No, I won't lend you the money.
Owners corporations going to approach a bank, for example, and be assessed on their affordability to take out this 10-year loan. How do they do that? These are buildings without sinking funds. Is it the individuals who are going to be putting their names on, you know, the repayments, the affordability when being assessed?
Yeah, I think it'd be the owners' corporation, because it's, you know, ostensibly it's common property, isn't it? The facade. So I would have thought, you know, I don't think it'll be the individual lot owners, but of course they'll be responsible, presumably, for special levies that'll be need to be raised to fund, if not, certainly not the loan part, but other parts of any sort of capital works that get undertaken around the building. So.
And the Commissioner's office is deciding which project happens first. The budget, the design, the contractor.
Well, look, they haven't come out with anything as specific as that, but they've identified these 255 buildings. So I suspect, as I read it, that if you're not one of those 255 buildings, then you won't be contacted and invited to participate in Project Remediate, which really means that you won't get the benefit of the interest-free loan. But they're not going to make the loan, as you say. They still have to go out there and source the loan, but they're going to put in place a financial provider, and apparently they're going to tender for that.
And they'll set the budget, the building commissioner's office, they'll set the tender and appoint the works to be done.
I wouldn't have thought. I wouldn't have. I wouldn't have thought. But I don't think the government or the building services office will have, the commissioner will have that greater involvement. But in terms of, I think his designer will obviously have some role in agreeing. Maybe the scope of work has to be signed off by the principal designer, or there has to have been some sort of consultation process between the principal designer and the project specific designer. It may be. I mean, you know, one thing we have seen through all the various reforms is the uploading of drawings and documents into the government portal, because they've made no secret that they want to have a repository of all the documents relating to one particular building located in the one place. So whether there's some requirements that the drawings get approved by the principal designer and get uploaded into that portal, just again, this is just me thinking out loud off the top of my head, to get some consistency with what they're doing, ensuring all documents are located in the one place in respect of a specific building.
The government's not underwriting this, they're just trying to facilitate.
Correct, absolutely. They're just exactly. They're trying to expedite the remediation process. So they're basically saying to owners, corporations, right, here's a financier, we'll pick up the interest. Interest is not a lot at this point in time. It might have been a bit different when rates were a little higher than they are now. And they're going to provide obviously a project management service. So again, it's interesting to see what that actually looks like when it actually comes out, and also this design service.
Usually the financiers will require a quantity surveyor to prepare a cost estimate.
Yep.
And then sign off on
progress payments.
Yeah.
Correct. Yeah. So it's very difficult to see why any of that would change. You know, I still think that will change. The only thing is it's just like any development where you've got a financier involved, that, you know, if you tick the box, the QS, the agreed or appointed QS agrees that the progress claim's valid, then the financier will release the funds. Yeah.
Where do we find out where these buildings are? Is there portals indicating which buildings are involved?
Look, to date, this magical list of buildings that have been identified has not been released to the public. So I haven't seen it. I don't know whether anyone else has got anything on the QT, but the short answer is I don't know at this stage where they are or who they are, because there's been a lot of...
Buying a unit in one of these buildings will know.
Absolutely, and there was a great furor some time ago. The banks also want to know.
Yeah.
right? Because the banks want to know because they're lending against these units. But there was the counter argument that was put forward that if you published this list, then the value of those particular units would fall through the floor. So, and there was also some other arguments that suggested they might have been more vulnerable to attack because they were more combustible. So there were arguments for releasing it. The banks were an interested party, the Real Estate Institute, and you say potential buyers would like to know whether the buildings that they're buying into is one of these 255. On the other side of the coin, there was some commercial interest in terms of what it might do to the value of these units if they were in fact identified.
I think that the list in Victoria has been published.
Victoria has, certainly New South Wales, I don't believe it has.
I think the original.
Potential buyers will be able to find through research through the minutes of the Australia organisation, they should be able to find whether a letter from the task force
Correct.
has been issued to them. And the task force letter requires that a report be done to determine whether it actually has got combustible cladding on it or not. So I don't think there's any risk if they do their due diligence.
But I think the due diligence has got to extend beyond the standard off-the-shelf strata inspection reports that a lot of people buy.
Well, the task force didn't allow just standard strata inspections. They required specific inspectors to do that. And I mean, at ACOR we used to actually have to sample testing and sample That's typically what gets done. And then a C10 certified will provide a report that says it's okay and it's not. And I suspect that the principal designer will have some sort of instruction from the commissioner to allow partial removal of cladding only or not, because a lot of the reports that have been done by consultants as a result of the task force letter says that as long as you remove X amount of layers or provide certain barriers between ACP, then that should be okay. I think that the commission is probably going to provide mandate to the principal designer to say, don't accept that it's all going to come off, or something along those lines.
I'm not as close to it as you is, but my understanding, what I heard was that most consultants were not really coming up with those solutions, that partial removal, and really for reasons of their own liability, were just saying remove and replace the entire lot.
There are many.
That's if you find someone that'll do the report for you.
There are many that will,
My earlier comment was more about from the incoming purchaser that engages someone to do an inspection of the strata reports. They got to dig a little bit deeper. Your standard, I don't know what they cost, $250 or $300 report might not get down to actually finding that task force letter. And if you don't find that task force letter, then the incoming purchaser is really sailing blind, short of finding someone to go and take some samples and send this away for testing themselves. So they've got to be prepared to, if there's any suspicion, to dig a little bit deeper through the records. They're entitled to access through the records, through the vendor. So yes, you're right. Go looking for those letters. Yep.
This is exactly what happened in the UK, what the recommendations are, what they did in the UK. And all it did was the owners of the units all declared bankrupt. So because they're liable for cladding and stuff like that. So if you own a unit, then there's a special levy put on to remove the cladding and stuff.
Yes.
There's just been people declaring bankruptcy in these buildings.
Yeah. I mean, there's all sorts of estimates around, but they talk costing individual unit owners sort of $40,000 per unit. Look, that's a lot of variables that'll go into determining what that figure is, but it's not $1,500 a unit.
Yeah.
That's the point. You're right, absolutely. And what happens if individual owners just can't afford that, and then throw in difficult times with jobs.
All the recommendations that you just come up here, what's going to happen is exactly what's happened in London.
Right.
Word for word.
Yeah. Right. Okay.
Yeah.
Right.
I got two nephews in London who's gone bankrupt for the same reason.
Right.
Yeah.
Yeah. Well, on that cheery note. Anyway. Okay. Thanks very much. Thank you.
Where am I going?
You got to talk to Dale through the.
Dale's backseat driving, is he?
It should work. We should have control here. There we go.
Right.
That's what I say.
Just the forward arrow.
Righto. Thank
Forward
you.
arrow?
Yeah.
Forward goes forward. Okay.
Forward arrow.
All right. Morning, gentlemen. Apologies for being late this morning. A little praying on the M1, you know, holds everything up. But got here eventually, and of course you're able to eat your breakfast undisturbed by legal issues, so that's probably a good thing. I'll just circling back to what Mark was talking about. One also wonders where the intersection between this project, this scheme, and owners' corporations suing builders and developers for putting the cladding on in the first place is going to end up. Presumably the builders and so on aren't going to be able to access this scheme? Is there some mitigation factor that the owners' corporation has to take into account, reveal if they have access to this, but they're suing the builder and developer at the same time to pay the cost of remediation? Is, in terms of what they're suing for and the scope of works to remediate, is that all of a sudden going to have to stop so they can consult the principal designer? Where is all that going to happen? As usual, devil's in the detail, and I guess we just got to wait and see. But I'm sure someone's going to pick it up, particularly a builder or developer who's being sued, who's going to pick this up and say, hang on, you've got to go through this project remediate protocol first before you can say how much money you reckon I owe you to remediate the building that you're saying that I haven't built properly, or I shouldn't have used the cladding. So I think there's a way to go on all this. Okay, so this morning I'm talking about expert evidence via video link. So no doubt a number of you who do expert services for mostly in NCAT, I suppose, but also District Court, Supreme Court, will probably have been given some evidence by video link. Okay, so the restrictions COVID restrictions are starting to lift, and there are some courts that are going back and doing things in person. It's certainly not consistent across the courts and tribunals, but I think the video link evidence protocol is going to be around with us for a little while longer. And one of the things that's, of course, that's come out of it, because it's all a bit strange for us, is you're on video. If you're in a court and you're sitting in the box, you know everybody's looking at you. But if you're on video at home or in your office, you've got to be conscious: are you being watched? Are you not being watched? Is your microphone on? Are you on mute, etc.? And there's a degree of informality that has crept in as a result of this. And so this is just a reminder that just because you're at home or you're in your office and you're not actually in the court, you've still got to be aware. Now let's see if this works. Right. Moving on.
Yeah, it's moving.
It is?
No, it was.
Let's try again. Mouse click. Right click. Come on. Not happening. Where is Dale?
He's at home.
Dale.
By video link. It's on his. We're sharing his screen.
Oh, here we go. Well done. Okay, so this wasn't a building case, but nonetheless they had an expert. It's about loss of profits. In fact, evidence by video link. The guy appeared by video link. The expert, he was wearing a sweatshirt, which didn't please Justice Ball, and you could see on the screen when he wasn't actually giving evidence himself. He was doing other work. He was playing on his phone, sending text messages. Who knows? He might have been playing Tetris or whatever you do on your phone, and sending emails and doing other work. And this is all while the camera's still on. So this didn't please Justice Ball any. And if we can move on here. And as it indicates, actually in his judgment, Justice Ball made mention of this. Now we're moving on. Come on. Press it again.
You wouldn't turn up to the Supreme Court with a sweatshirt.
No, you wouldn't, and you wouldn't sit in the witness box playing with your phone. Oh, here we go. There he is at work. So you've got to be a bit careful. Which one we're to left?
Yep.
Okay. Oh, there we go. All right. So this is the comment that Justice Ball made. I won't read through it. You can read through it yourself, but or yourselves. But it's that degree of formality still has to be there. It's very important, and the importance is that these are court proceedings. These are very important to the people who are participating. They're important to the community, and if we're going to have any respect for judgments in our courts and tribunals, that respect has to be shown, particularly when you're actually in the court and giving evidence. So this was the comment that Justice Ball made after he noted that the guy had been sitting in a sweatshirt and was fiddling with his phone. So there we go. There was a sting. It wasn't just the comment. The other thing that Justice Ball said was, well, perhaps this expert shouldn't be paid for his time because he was doing other things. So it's not just a case of embarrassment. It's also a case of you might not get paid. And I should also say that this was the expert for the defendant, and his expert's report wasn't accepted, or the other expert, the plaintiff's expert, was preferred over him. You would like to think that that was purely objective on from the judge's point of view, but I imagine that he didn't actually approach this guy's expert report with full confidence and was perhaps looking for a reason to favour the other expert. So it's a sting both for the expert and also for the client. What's the takeaway? Good. Hang on. Gone too far. So this is a confession. So this is me actually going to court early last year by video link. As you can see, I was doing the newsreader thing. So I've skipped over the takeaway, unfortunately. So the takeaway is, if you are giving evidence by video link, just assume you're in a court, behave in exactly the same way, and certainly don't be tempted to have other electronic devices or two screens or whatever and fiddle with them while you're in court. I mean, if you want to take a risk, you can look and am I actually on screen? Am I muted, etc. But our advice is treat it as though you're actually sitting in the court and don't do the other. So that's both my confession as in what not to do, although I might do it, and that's it. That's also my joke for the day too. Thank you, gentlemen. Any questions? Nope. Okay, thanks.